Hello students, welcome to the business law session for B.B.A 5th semester. Students, in our previous class we are discussing about the various elements which makes the contract valid. So we have studied proposal, acceptance, lawful consideration, free consent, competency of the parties. So we have studied these elements which makes here the contract a valid contract. Now another two aspects I will be discussing here, the elements. One is section 23 and 24 mentions the object of the contract must be legal. The object, the agreement which they are entering, both the parties, the agreement which they are entering, here the object or the subject matter must be here lawful subject matter. So we call it as legal objects. And agreements declared void by the law. So if they are declared void, the section 26 to 30 covers this. If they are expressly declared void by the law, you cannot make it as a subject matter. You cannot take it as a subject matter. So which are the instances there? Suppose if any of these here instances come which are forbidden by the law, then what we say that here the agreement will not lead to the contract, or it is not a valid contract, it is not enforceable in the court of law. So these aspects we are going to discuss, and this one we are going to here mainly conclude the elements. Then I will be discussing two very important things, contingent contracts and quasi contracts, in my next class. What is contingent contract and what are quasi contracts? Examples for that. Whether contingent contracts are enforceable or not, we will discuss. Whether quasi contracts are enforceable or not. So that aspect we are going to take in our next class, which are important from your examination point of view. So today we will try to here complete about the elements here which makes a contract a valid contract. So the object here must be lawful. So if you only say that there must be an object in a contract, object or subject matter must be there, it is not enough. So the word here legal, lawful, it must be added. Lawful object must be there. So what is meant by the lawful object? So it should not be forbidden by law. The object should not be forbidden by law. The object must not be against the public policy. The object here must not be here a hurting or mainly here threat to the life of a person. So like this, mainly the object, if you are making the subject matter which you are entering is here lawful. You should see that it is lawful. So it should not be forbidden by the law, it should not be against the public policy, it should not here mainly in a nature of assaulting a person or here hurting a person or his property. Any of these aspects here will vitiate the contract. The contract is said to be here unlawful because that is here the object is unlawful. So instead of using the word contract, the agreement itself is unlawful, what we said there. So we call such agreements as illegal agreements. They are not permissible in the court of law. They are not entertained in the court of law. Any such subject matter is there. So then that object becomes unlawful and it is not enforceable in the court of law. So the legality of the object must be there. The object must be legal. For example, if you take mainly here the example. Now, running of a distillery. Distillery is mainly production and manufacturing of the alcohol. Running a distillery is not here unlawful. You can enter into a contract here for establishing a business here in the distilleries. Now, if the law comes into force stating that the manufacture and the production of the liquor has to be stopped in a particular area and your distillery is located in that area. Now, the question arises whether that mainly the running of the business makes here a validity or not. Running of that business. If you permit it, you are vitiating the law. You are breaking the law. So, law is taken to be above all, and even if the law declares, that is why we say change the circumstances, change the law may vitiate the object. The object may become unlawful there because of changed circumstances and the changed law. Now what we see here is a changed law. The law has changed, and here law at any time it changes, everyone has to bow down before it. So going against the law, if you permit to run, if you say that before this law I have taken the permission here, then I am allowed to continue the distillery business, it is not so. You have to stop it. You have to break here, mainly close that here the distillery function during the operation of the law, even though you have brought it earlier. So that is what here changed circumstances, changed situation, changed law may make a contract a unlawful contract. It may become unlawful. Now contract running of a business is here of a distillery is very valid. Yeah, but when the law is there, the object becomes unlawful and it is like that unlawful agreement or unlawful contract there. So like this, what we notice is the object must be always lawful there. So this is section 23 and 24 says, and if the object is unlawful, the contract is not enforceable in the court of law. It is declared as unlawful. And there are certain agreements which are expressly declared void. Section 26 to 30 deal with that. And what the law says, you cannot make the object or the subject matter of the contract here pertaining to these agreements. Based on these agreements, you cannot form a contract. That is what the law says. Which are such contracts? Agreement with a minor, we have seen it. Agreement with a minor is a wide, not only wide, ab initio. Right from the beginning of the agreement it is self-wide. Any agreement made with the minor is wide. So expressly it has prohibited. The prohibition is there expressly. Even the same thing you can take. Agreement made with an unsound person, it is wide. Because the same law applies here, that to of a minor. So what we say that here agreement with a minor or an unsound person is here expressly declared void. Expressly declared void. Who has declared it? The law itself has declared it void. No other person has declared it. It's a law who has declared it void. So then what we say that law here has changed it and we should here accept the law there. Because when we are living in a society, we have to abide by the law. The law is there to regulate the behavior of the persons in the society, and if you break the law, it is punishable. So now what here? Agreement made with a minor or an unsound person, here you can say that even an unsound person. With an unsound person also an agreement made which is expressly declared void by the law there. That is the first one. Agreement under the mutual consent. Here under the mutual consent here, but there is a mistake. So agreement under the mutual consent, a mistake has been committed. So both the parties have committed a mistake. There is a mistake from both the parties. So both the parties are at error. We have seen this before when we are discussing the free consent. Mistake, it must be bilateral. So it is a mutual consent is there, but it is a bilateral mistake. They are under error. I had given you the example. Here A and B has made an agreement. A here mainly proposes to sell his house to B, and B agrees to purchase whatever price is quoted. But when they are entering into an agreement, they are unaware that the house has been accidentally burnt down. So both are at error without knowing that the subject matter is destroyed. So they have entered, that is mutual consent. The consent is there, mutual consent is there, but they are under bilateral mistake. It is under mistake, there is an error. So for that reason, agreement where such is here the mistake is committed and it should be bilateral, not unilateral, not mistake of law. If it is a mistake of law, it is not excusable. If it is unilateral mistake, only one party is at mistake, it is not excusable. If both the parties are under the error, mistake, bilateral mistake, then the agreement is declared void. That is the error. Then against the public policy, if the agreement is against the public policy, then we say that here law declares it void. For example, we have studied here the alien enemy. Making a contract with an alien enemy on agreement with an alien enemy is not permitted. Alien enemy, a person who is staying abroad with which the India is at war. So he becomes an alien enemy. Any agreement being made because it is against the public policy. So such agreements are not allowed. That is, if it is against the public policy, the law has expressly declared it void. Agreement in restraint of the trade. You cannot prohibit any person from taking up a business, a profession. You cannot put any restriction. No restrictions can be put here. For example, X, here mainly X is working in Y's pharmaceutical or medicinal shop. And after some years, X wants to leave the job and establish his own establishment. He wants to set up his own medical shop. Y says that you can leave the job but you cannot establish a medical shop in my locality. So he is restraining that person from doing a lawful business. So such restrictions are not permissible. They have been declared void by the law itself. That is why here any person is allowed to here do any type of business provided it is a lawful business. Agreement in restraint of marriage. This is also here lawful. No here restraints, no restrictions can be put on marriage. Such here agreements are void there. And the last one is the wagering agreements. Wagering agreements are betting agreements. Betting agreements. So it is just a betting on a future event. And this is the most popular what we see here in the cricket matches. Usually we have the wagering agreements. That is betting takes place. So this team will win and this team will win. That is what we have got the bettings in the newspapers. You will be reading it. So many persons have been arrested because of the betting in the cricket match. They are all wagering agreements. They are all and they are not enforceable in the court of law. If any party is deprived or if any party is a victim to such agreements, he cannot go to the court of law and claim justice. They are called as wagering agreements or betting agreements. So this can be asked for 2 marks. What is a wagering agreements? Betting agreements. And the law here expressly here declares it as void. Such agreements are not permitted. Betting agreements are not permitted in the court of law there. That is what you can get it in 2 marks question. So you must be able to answer and you can give this best example of the bettings which take place when the cricket match is going on. Particularly when India and Pakistan matches is going on, we have a lot of bettings taking place. So such agreements, if any person is a victim to such agreements, here he cannot go to the court of law and claim the justice because it is expressly prohibited by law. So such here agreements which are there declared void by the law, you cannot put it in the object or the subject matter of the contract there. So section 23 to 30 mainly speak about that legality of the object. And there are certain agreements which are expressly declared void. You cannot make it as a subject matter. You cannot include this and make the object lawful there. Their agreement is itself declared void means the law has expressly stated this cannot be a subject matter. So leaving this here, you have to do that. Mainly the object must be here lawful. The subject matter of the here contract must be lawful there. So these are the elements which have to be noticed to make a contract a valid contract. Valid contract is enforceable in the court of law. So these are the two other aspects which you have to know that. So with this, we are concluding about the elements, and in my next class, I will be speaking on contingent contract and quasi contracts with examples. So with that, we are going to complete module 1. When I complete contingent and the quasi contracts, module 1 will be completed. That is what we will discuss in the next class. Thank you.